Welcome, everybody, to State Bar Association training on complying with the Maryland Open Meetings Act while dealing with social distancing during the COVID-19 crisis we're facing. This is sponsored by the State Bar Association State and Local Government Section. It's a virtual training via Google Meet. It should last for about an hour. My name's Frank Johnson. I'm chair of the State and Local Government Section Council for the State Bar Association, and I've been doing Open Meetings Act trainings for the University of Maryland Academy for a couple of years, and I also serve as Deputy City Attorney for Gaithersburg. Joining me today is April Ishak, who is chair of the state's Open Meetings Compliance Board, so she certainly works with these issues as well, and she also serves as City Attorney for Havre de Grace. We both also want to thank Ann McNeil. She's the Assistant Attorney General who advises the Open Meeting Compliance Board and really has had a big part in putting together PowerPoints and trainings overall on the Open Meetings Act, and she works very closely with both of us. We also thank Angela Monroe and Bill Hall with MSBA for coordinating this. Just a couple of quick notes as we get started. As I noted, it's set for about an hour. Our PowerPoint presentation will probably go for about 35 minutes or so. And then we'll take some questions after that. And certainly in the meantime, if you want to post them in, that's fine. Google Meet lets everybody send in a question as it comes up. My guess is that we will probably plan to answer questions at the end. But if something does come up that we think is very helpful to help illustrate a point, we may even answer it in the meantime if we notice it. We do underscore that, of course, this isn't legal advice. We know most of you are probably attorneys advising counsel, so advising your local councils, local boards, local commissions. Basically, this is intended to try to be a how-to. Some of it is very related to complying with the Open Meetings Act. Some of it are also some practical questions as far as dealing with things like public hearings and public input, which really isn't an Open Meetings Act requirement, as we will underscore several times. This is also something new, so we certainly apologize for any glitches or adjustments, and I think Angela and Bill do a great job, so we think this will move very well. We're also going to make an effort not to try to talk over each other, and hopefully the PowerPoint slides and our organization in that regard will work very well. So as we get started, just in terms of the introduction, I've already kind of said who I am, and I don't know if April, if you would like to say a couple of words just to welcome everybody.
Well, thank you, Frank. I would like to again thank MSBA today for putting this program on and getting it together. And
absolutely. And
yeah, it's been great. And also Ann McNeil, who's been instrumental in getting these materials together. I've been working with the Open Meetings Board since June of 2015. A year ago, I became chair when the prior chair stepped down. So my term should actually be ending soon, but I've had a great run of it. I'm just very comfortable with the people I've been working with. And Frank, we've had a chance to present before. So I really feel like there's been a lot of direction in the past couple of years with Ann, especially in clarifying some of the Open Meetings Act issues. So this program, I think, will help crystallize some of the issues for people, hopefully, with respect to the social distancing times and remote meetings and things of that nature. So I'm happy to have this program today.
Yes, thank you. And I know that your term is up, but I think you can serve more than one term now, right?
I don't know. We'll see.
Isn't that the way it is? Yes, we shall see. So we'll move into our first slide then. And in terms of our objectives of what we're trying to do today, just by way of a further introduction, look, during these public meetings, we're used to having the public attend, but they can't. With social distancing, even as we move through phase 1 and get into phase 2, there are going to be some restrictions and limitations on that. So how can virtual or online meetings and conference calls comply with the Open Meetings Act? That raises the questions of what steps are required before, during, and after. When we say, look, people have to have a meaningful opportunity to observe. What does that mean? What are the elements of that, particularly in a virtual setting? What information does the notice of the meeting need to include in order to let people know and allow that access? Is there any change in conducting the meeting or conducting a closed meeting? I can tell you in advance, pretty much the same rules apply, but they may apply in a different way just because it's a different setting. And of course, the question that we'll touch on quite a bit are minutes still required after a meeting. I can anticipate that I can tell you by anticipation the answer is going to be yes to that, but we'll lay out how relevant that is. And I think we can move right to the next slide then.
So the Open Meetings Act requires that public business be performed in an open and public manner. The idea is that the public is entitled to observe the performance of public officials in their capacity and their deliberations and decisions and the making of the public policy that involves. It does not involve, for example, if there happens to be a quorum of a public party out and they're participating in a charity golf tournament, for instance, and they're not talking business, that wouldn't count. So it really has to do with the public business that particular public body is given the task to take care of, and their deliberations in coming up with public policy and whatever that public body is given the task to do. So that's the focus of the Open Meetings Act. There may be a time where there is a quorum that's not in a meeting setting and they start talking about policy issues. That would, again, now you start coming into the Open Meetings Act venue, if you will. So again, if there's a quorum of people, that's what we're concerned about, and whether they're deliberating on public business. So next slide, please. There are three elements. I'm sorry, Frank, that's you.
Sorry, Frank, you're muted.
I just unmuted myself. That's fine. So there are three key steps to complying with the Open Meetings Act, and this is something that John Mathias, who's the Frederick County attorney, and also has participated in this training, which we think for about 10 years, has really emphasized. We talked about before, during, and after. Well, here we are. Before, advanced public notice and an agenda. And agenda is a little bit different than public notice, and we'll touch on that. During, ensure public access. That is to make sure that the people have the ability to observe, as April just talked about in terms of the basic rules as to the intent of the Open Meetings Act. And then afterwards, prepare and release minutes. That is a way for people to know what happened and what was done. And if we can move to the next slide, and April, I think that's yours.
There we go. In-person meetings are not always required. We've seen this in the case of 2-0 versus Kim, where one of the public body members participated by telephone conference call. The Open Meetings Board has also had the occasion to consider whether an open meeting can be conducted by a telephone conference call where all parties could be heard and where the public was allowed to call in and listen. The Open Meetings Board itself has we have an annual meeting every year, and we allow public access by telephone call-in. Because we are a statewide body, not everybody can attend where we're hosting our meetings. So either when Jonathan Hodgson was the chair, when they were in Annapolis, now they're back in Baltimore at the AG's office. So we will allow conference call-in for our open meeting when we have our annual meeting. So it is definitely an acceptable method, and is one of the preferred methods if you are going to have what we call a remote meeting, or a meeting where people can't be present in person. The main thing is that you need to be accessible to the public. The public needs to be able to, again, observe the deliberation. They need to be able to hear all comments and discussion. If you have poor telephone reception, this could be a problem going forward. If, for example, there's some counties in Maryland that do not have good mobile phone access, so they would probably need to call in on a landline. If you're in one of those areas and you're using only mobile phone access, there might be a problem. Or if you're only using a internet-based program in an area where We'll get into this more later, but we're an area where there might not be internet access. That could be a problem. So the key is, are you accessible to the public by whatever means you're using, and can the public hear all comments and discussion? Next slide, please. So virtual meetings are permitted. It's not expressly stated in the Open Meetings Act, but again, applying the same principles, access to the public and that everybody can hear each other. So what we've seen as part of the governor's stay-at-home orders, this rise in the use of things like electronic online communication such as Zoom, Skype, Google Hangouts, or Google Meets as it's now called, and others, has been a popular option, particularly in areas where most people have access to the internet. In person, but live feed only for remote public observation. That is one method. One of my clients is using it. It live streams right to the website and to YouTube. Most people have access to YouTube, even on their phones these days. It's even available on Comcast cable network. So for even people who don't have access to internet, it seems to be, we haven't approved it specifically, but that also seems to be something that has widespread availability for people. And then a conference call option, you can add that in to any of the other options if it works technologically speaking, so that people who don't have access to the other things I just mentioned, they can still call in and observe and listen in on that line. It's important that we use these now during COVID-19, but in the future, we may be using them as a more regular part of the practice, particularly boards that may be separated by distance and miles, where it might be easier, or in the past where some boards may have, public bodies may have canceled meetings because of bad weather. Maybe now they can continue to hold them with the remote access. Frank, did you want to add anything to that?
Yeah, I would say the other thing is we are learning how to do this. All of this operating remote, I remember, maybe I'm particularly old-fashioned, but 90 to 120 days ago, if somebody had said, let's do a Zoom meeting, I would have wondered what they were talking about. Well, I've done it enough since then that once you become familiar with it, as April's pointing out, it does become a practical option. And that can be important, especially given, which we'll touch on a little bit, there are some restrictions in terms of a public body making a decision on public business by using email. Well, maybe the virtual options that are becoming a bit more widespread and that we're getting a bit more used to can provide a way to do that. So if we can move on to the next slide then, and what we want to talk about is, we're talking about public access as being critical. So how can we do that? Well, the standard is that the meeting has to be reasonably accessible to the public. Now that means, as April was talking about in terms of mobile phones and internet and phone lines, it has to be accessible to the community you're serving. So that means some consideration of what options do they have? Do they have the means, for instance, if you have everything online and require a Zoom meeting and no other option? For some folks, that may not work. If you don't have a community that has the mobile connection, if you don't have a community where you know people don't have that many computers or computer access, that's not going to work. However, we have recommended fairly consistently a conference call option for one reason, because that's an option that has been approved under the standards that we're following and suggesting as a, I don't want to say backup, but if nothing else works, that gives somebody the opportunity to call in and at least, we wouldn't say observe, but be present and accessible and hear what is going on in the meeting. And if we can move to the next slide. So the notice requirements that are the same. I had mentioned before that I could imply that they wouldn't change, and I can tell you they don't. Whether the meeting's online, virtual, or a conference call, the advance public notice has to be reasonably calculated to let the public know how they can access it. So if you can, certainly use the same notice process that you normally use. Whatever your practice has been, which may be posting, it may be posting online, it may be putting it on the front door of a city or town hall. If you can use the same process, that's fine. Do recognize, and this is more of a practical suggestion, that if you aren't using your usual practices, that is for the meeting, if you're doing this in a different way, virtual meeting, conference call, make some extra efforts to notify if you happen to have an email exchange and you don't normally send out meeting notice. You're not hurting yourself by making some extra effort, again, based on the fact that you're not using usual practices. What's the notice need to say? Well, of course, time, place, and manner, but basically how the meeting's going to be conducted and how the public can access it. Of course, they need to know when, but then if they're, and we'll get now for the next slide, if we can move to that, those options might include, for instance, for a conference call, what's the telephone number? There are, as we found this morning, there are going to be some access codes, so people need to be aware of that. For electronic online, very similar. Sometimes there's a link. Sometimes there's also the backup telephone number as we're talking about a conference call. Also, and I believe April touched on this as well, to ensure public access, an electronic online meeting can also be shown live via cable access, such as YouTube. Again, even if that is not the primary means that you're looking to, if the idea is to provide public access, that's a way to do it. If you have the cable access and you have the conference call, and then you're handling, let's say, a virtual meeting via Zoom or via Google Meets or another option, if there is a problem, and as I think we can say, sometimes we can anticipate that problems are going to come up, you have a backup. I think sometimes for IT planning, they call that redundancy, which seems to be a harsh word. But having a backup plan already in place basically can help you comply with the Open Meetings Act, which is our main point today. And if we could, April, I don't know if you have anything further to share on that before we move to the next slide.
No, I think you cover that pretty well, Frank. If I think of something going forward, I'll add it in. Nothing comes to mind right now.
Sure. Okay. Let's.
Okay.
Yep.
Okay. Other require. Oh, we're slide 9. Okay. Sorry.
Slide 10.
Oh, slide 10. Okay. So other requirements that apply, in addition to the notice, you're also required to publish an agenda. It's not the same thing as Frank had previously stated. Under our the rules of Open Meetings Act, it's to be provided at least 24 hours in advance. It specifies the order of operation, topics of discussion, and the items of business. Most groups, bodies use agendas. They need to be posted ahead of time. That is the main thing. We have seen situations where some public bodies did not understand that was an additional requirement, and they've kind of got themselves in a little hot water with the Open Meetings Board because they did not post their agendas. So the other thing is you should post your agendas in the similar way all the time so that people know where to find them. If you are posting your notice in one place and your agenda in another place, that again has caused confusion, and while might not be an outright violation, may be one fact that the board considers in whether or not there's been a violation. So if you're going to post your agenda, be consistent with where you post it. Don't hide it on your website. Don't hide, just be consistent. There are times, sometimes it occurs that an agenda is amended at the meeting itself. There's nothing wrong with that. That happens. That's not an Open Meeting Act violation. If there are factors that indicate that it was done in a way to circumvent the Open Meetings Act, we haven't had that happen yet, but that might be a different question. But where an agenda is just amended as a matter of course, oh, this information became available and we're amending the agenda, that by itself is not a violation. And then the other thing you're required to do as part of the Open Meetings Act is prepare the minutes and have them available afterwards. Usually this is done following the meeting. Pursuant to the Open Meetings Act, Section 306. They must be available on request during normal business hours, as well as posted to the extent practicable. So what we look at for that is generally, if you're, again, like the agenda, you need to post the minutes. If you don't post them on the internet, at least have them available. It needs to be done the same way consistently, or at least come up with a practice if you don't have one. Because when people ask for them, if there's a particularly contentious meeting, for example, and that's the only meeting where nobody can seem to find the minutes, then you're gonna call into question the practice. So you want to be consistent with your minutes. And I was going to get into the approval of the minutes, but Frank, did you want to talk about anything of the agenda before we move on to the more detail on the minutes?
No, I think you've covered that well. The one point I was going to make is that in the midst of a meeting, sometimes you're going to change the agenda. There's going to be a shift, and that's perfectly acceptable and understandable. Sometimes there'll be a new issue that comes up, but as April had noted, there is a provision of the Act that prevents efforts to evade the intent of the Act, which is to provide notice and provide at least a basic agenda in advance.
Right. And then with respect to the minutes, I was going to say that when we're in this period where people aren't meeting in public quickly, one meeting after the other, or if your board or your public body doesn't always meet in person, and you don't have the opportunity to approve minutes in person, what the Open Meetings Board has accepted is if all you're doing, now we'll get into email later, but if you're going to email the minutes after the meeting and seek approval of those minutes, they can be approved by email. That's the only thing that you can approve is the minutes. And then at the next meeting that you have, that's an open meeting, you would vote in public to approve the minutes that you've already approved by email, but you're now ratifying that vote. And the reason we do that, or we accept that practice, is because we want those minutes posted as soon as practicable after the meeting occurred. And if you have a long gap between meetings, for example, you have maybe a board, a public body that only meets twice a year, you might not want to wait 6 months, because from our rulings, that's not going to be quick enough. That's going to be a delay. So we would allow that email practice of approval of minutes. And then at the next meeting, there will be a verbal vote of approving those minutes at that time. That's an acceptable practice to get the minutes approved in a timely manner. You don't have to hold a whole separate open meeting just for approval of minutes. Frank, did you want to add to that point?
No, that's very helpful. One thing I will point out, I think because this being a state bar presentation, you will often have commission members recuse from approving minutes because they were not present. I see it all the time. And sometimes you will end up on a 5-member board where you've only got 2 or 3 that were there. There is not actually any requirement under any rules, Robert's Rules of Order, or any other requirement that you have to be present at a meeting in order to approve the minutes of those meetings. And that's because the minutes are not a transcript. You're not testifying to everything that was said. What you're testifying to is that the minutes are simply a fair and accurate rendition of the actions that were taken. So no great need to recuse. That's not an Open Meetings Act issue, but since we were touching on the minutes and giving some detail on that, I will offer that. But no, I don't have anything else on the minutes. And I think if you're ready,
go to the next slide.
Move to the next slide. Yeah.
Okay, the closed meeting requirements are the same. We need an exception must apply. I mean, in terms of the notice, you need to have notice of the closed meeting. You need to have an agenda or at least a topics to be discussed. One of the exceptions must apply to the closed meeting. And you have to provide a reason to close the meeting under section 3305. I forget how many enumerated exceptions. There's like 12 or so.
Actually, we touch on those in just a sec.
Yeah. So, but the public, one of the things that confuses public bodies is there needs to be a public vote to close the meeting with a written statement. Now, on the Attorney General's website, there under the Open Government section, there is a copy of the closing statement that's required. And the reason we do that is the public is allowed to challenge the vote to close. They can say at that time, no, I don't think this is a valid reason to close the meeting. So they have the right to do that. I've not seen that. I should say I've seen that happen a few times. It doesn't happen very often, but it has happened a few times over the past few years that I've been on the Open Meetings Board. But it's not common. But even though it's not common, the public still has a right to observe that vote to close and to object if they so desire. And then once you decide to close the meeting and you've given the proper notice and you've given the closing statement, You must be careful to stay within the exception for which you close. We get a lot of complaints. I would say a good chunk of our complaints are that the public body exceeded the scope of what the closed meeting was for, and they ventured into topics and areas that were not within the closing statement and not within the exception. So that tends to be confusing to public bodies. I know I've been counseling public bodies where I've had to say, let's bring the conversation back to the topic on which this was closed. Very often those were meetings which were for legal advice, which is a valid reason, but sometimes the discussions meander off into other areas. So the key is just to keep those discussions under that topic. Afterwards, you provide a summary of the closed session that can become part of your minutes of that meeting, or if it was part of a larger meeting, sometimes you do a closed session as part of a larger meeting. If all you did was the closed session, then you do a summary minute of that closed session. And you're also required to keep a regular minutes of the closed session, and they can be kept confidential. So there really should be 2 minutes of your closed session. There's a summary version that the public sees, and there are minimum requirements that need to be in that. And also the more detailed version, which I recommend you keep as a confidential set. That way, if anything comes up in an Open Meetings Act complaint, we can review those closed minutes, and we don't have to reveal them. They still remain confidential, but that will help us in evaluating whether the Open Meetings Act was complied with. Let's see, Frank, did you want to add anything to that?
Just the last point that, and that's really a practicality, that if you are meeting virtually in an open meeting and you go into a closed session, it's not going to be a matter of, as you are in a normal situation in town or city hall, and simply say, okay, everybody leaves. That's not necessarily going to happen in the Zoom setting or Google Meet setting. You're going to probably have to go to a whole different link, an entirely different link, in order to make that work. That's just a practical note. And I think other than that, you covered that pretty well. And actually, the next slide, I believe, gets into some of the closed meeting minute detail.
Right. Yeah, and just a point on the practicality point. Yeah, when you're in a virtual meeting, it does behoove you to leave that link or that room and move into another setting, because I have had a situation where it wasn't mine, but it was another public body, went into a closed session and the live feed stream was still running because they stayed in the same room. They never left the room. And this was prior to the COVID thing, but it just happened. They live streamed their meetings and they went into closed session and nobody turned off the live feed. So it was an example where they didn't physically leave the room. Nobody turned off the feed. So their closed session ended up not being a closed session. So I don't know the result of what they talked about, but I just thought that was an interesting, like, who was on duty that day that didn't pay attention. So I don't think at the end of the day it was hurtful, but just be aware that that's a possibility. So minutes after a closed meeting, I think I touched on some of this. The purpose, there are specific things you need to include: the purpose of the closed meeting, the citing authority, vote to close, the topics and matters actually discussed, the actions taken, if any. Sometimes there's actions taken in the closed meeting. I tend to recommend that they discuss amongst themselves and wait until they go back into open session to take an action. If they do take an action in closed meeting, then they need to, again, restate the action taken in open session, and then at that point, explain the reasons of why they voted that way. The other thing that's important is, in addition to stating the purpose of the closed meeting and the section that applies, the exception to go into closed meeting, the other thing you need to say is the reason that you go in. And a lot of people forget that the reason isn't necessarily the same as the exception. Now, very often, the reasons my public bodies that I counsel go into closed session, as well as the ones we deal with on the Open Meetings Board, relate to legal advice, pending litigation, or staff reports relating to litigation, things like that. So in those scenarios, the reason is pretty basic. It's attorney-client communications are privileged, and they're entitled to that privilege. Other ones, a common one is personnel matters. Personnel matters are privileged, it's confidential information because it could embarrass the person who you're talking about, especially if it's a bad review or something like that. So there are so you need to actually add the reason. That, I think most public bodies are getting that now. It used to be they would just cite the section. So in addition to citing the section, cite the reason. It may be obvious to attorneys or people on the public bodies. It may not be obvious to the public. So we need to also add the reason for closing. And then there's also the administrative function. The minutes need to be included. On the closing statement, there's also a section saying what should be included in those minutes, which include the matter discussed, date, time, place, persons present. The administrative function, I will tell you, rarely applies. People like to try and scoop everything up in that administrative function. The board's position has been consistently, if it's not explicitly within an administrative function, then it's likely not covered there, and it will be subject to the Open Meetings Act requirements. Frank, did you want to add to that?
Yeah, you can't be creating any policy, setting any rules, or setting any standard. The administrative function really is intended to be the executive element of it, or a very practical task. We'll touch on that as far as a good example. There's just some of the practical details of logging into a virtual meeting when you're doing it for the first couple of times. Don't take for granted that everything is going to necessarily work. So you want to make sure everybody's linked and everybody's working. That's a fair administrative function, even if you do have a quorum coming in. One other point I'll make in terms of the actions taken, April's certainly right that if you're making an ultimate decision on a public issue, that should be done, always deferred to the actual public meeting. But sometimes an action taken may be directing staff to look further into an issue. It can be a bit less of a formal public decision, and that should also be noted in the minutes as well. And we can go on to the next slide then. That one details what the 15 exceptions are. I won't go through every one here. April had already mentioned personnel matters, and that's not overall personnel matters. That's dealing with an individual employee who may have, certainly under the Public Information Act and their own privacy rights, confidentiality, receiving legal advice. If there is litigation, that can involve not only legal advice, but also updates from staff, acquiring real property, and then the others that are listed. One of the new ones there is cybersecurity. If there's an identified risk to, say, your computer system or network management, that's one that came in just a couple of years ago. There are also a couple of others, such as before a contract's awarded, if there's a question of negotiation, the actual contract decision, who gets the contract, whatever that might be for, that's a public matter. That would be in a public decision. And
we lost you for just a second there, Frank. Could you just repeat from where you were talking about if
other laws requiring confidentiality? I think it was when I was talking about a contract.
That was a public matter, but the negotiations aren't.
Yeah, but the negotiations, if there's some issue of a bid, and the issue there is mainly to prevent another contractor from getting an unfair advantage. And if we can move to the next slide. What we were talking about too was advanced meeting preparation being an administrative function. Well, that's a possibility. Again, this is getting ready to do a virtual meeting such as we're doing here. It may be limited to discussions on practical and technical matters as to how the meeting's going to operate, details and certain protocols. It might even be a matter of what's going to be included on the agenda. That doesn't require notice. That doesn't require a motion to close or anything like that. But you have to be careful that administrative function does not allow discussion on any matters of public business or public policy. So, as April was saying before, even when you do go into a closed session, let's say for a specific reason, a frequent problem is to move on to something else. Well, that can happen for administrative function as well. Keep it to the details. the technical details if it's closed in order to get everybody hooked in. For instance, you might call it a dry run. Before we do our first virtual meeting using this new platform, let's do a dry run. Let's make sure everybody can hook in. That way you find out if you've got a problem with a speaker or something like that. That's really what that's intended for. And then let's move to the next slide in terms of a couple of details of running a virtual meeting during COVID-19. The reality is it's requiring all of us to take some new steps. I had mentioned before that we would talk about some practicalities. That's part of what this is. Some of the suggestions, and this comes from talking with a bunch of different county and municipal attorneys, state bodies, as far as what works the best. Start with a roll call. That way you're identifying who's present. You have to proceed carefully. Speakers need to identify themselves before speaking. When you're all together in the same room, you may not do that. Yes, that may take a couple of minutes, but that needs to happen. Again, it's proceeding very deliberately to recognize you're trying to let people know what's going on as well and allow that observation to have some meaning. The chair should recognize speakers by name before they speak. If it is visual, raising hands can be helpful as long as the screen works so that everybody is on screen. And for instance, Zoom kind of does the Brady Bunch thing in that regard. Motions need to be deliberate. That is, I've seen some counties where the members will raise hands to make the motion. I've seen others where the chair will basically say, we're ready for a motion, and then somebody speaks up or says something. Voting is not a matter of all at once, everybody says aye. In order to be effective, I would recommend member by member to avoid confusion. What's your vote? What's your vote? It's very deliberate. The chair then announces the motion, the second, and voting. Again, that's just to go through the process. Again, that's being very deliberate. It can add a couple of minutes, but with that clarity, it actually can save time, because if it's not clear by way of some level of experience, you'll end up going back to the beginning if somebody didn't pick it up or didn't get it, because you do have a bunch of different remote connections all at the same time, and that basically what you're doing is keeping people on the same page. And if we can move to the next slide.
So how do you start your first virtual meeting? We suggest starting the meeting with an introduction. Oh, I think that's the same one. No, it's not. Sorry about that. Couldn't see my screen for a minute. So we suggest starting with an introduction by the chair, set the tone, have the presiding officer of that meeting, the presiding person, give an explanation of how the meeting is going to proceed. It helps put everybody at ease that they are trying their best to allow the public to observe the deliberative process. How members of the public body will identify themselves and how they will speak. Usually that will sometimes follow the typical meeting role or meeting process, but sometimes you might need to add a little bit, especially if it's where people aren't visually seen but only heard. You'll have to introduce themselves each time they speak, as Frank had said. The process for motions and voting, Frank really dealt with that, and also the process for public comment, if any. Some public bodies have eliminated the public comment portion of their meetings if they have typically provided it in the past, because it has not been something from a technological standpoint that has been easy to do. Public comment and participation itself is not part of the Open Meetings Act, other than for the public to observe the deliberations of the public body. So we really don't make any comment as the Open Meetings Board, or the Open Meetings Act for that matter. We don't deal with the public's ability to comment directly.
Although April, it would be fair to say, if somebody's objecting to a closed meeting, you do need to have some process in place to allow them to object. It may be email. If you're on a conference call, it's certainly easier. That would be the only exception. And I do see a couple of questions have come in on that, so I wanted to emphasize that.
Correct. And that was what I was going to say next, is that is the one point in time. And usually how that is done At that point, the person observing the vote to close, the public vote to close the meeting, would then ask for the closing statement so that they could review that. Sometimes that's done at the meeting, in which case the public body should be able to provide that as promptly as possible, if not simultaneously, at least quickly thereafter. And so at least the public's objection would be noted on the record that they object to the closing. Then they usually get access to the closing statement, and then from the closing statement, they will challenge potentially whether it was an appropriate closure. And then that's usually, if there is a complaint, that's when it will come to the board for complaint. If the public body does not provide the closing statement, there will almost always be if they didn't keep one or they don't provide one, that will probably most likely be an Open Meetings Act violation. But a public comment outside of that isn't really dealt with by the Open Meetings Act, but it can help to, at least if you typically, and again, this is not an Open Meeting Act requirement, but if you typically allow public comment, and not in a public hearing setting, but just in a regular meeting setting, to continue to allow, if possible, that to occur, but it's not a requirement. And then if you have any members that are there or not there, we have one member in our public body who's not been at the meeting. So make sure you do a public roll call of all the members of the body so that you know who's present and who's not there. Next slide, please. Other practicalities for virtual meetings. When you're not using your customary and usual practice, you can make extra effort to provide notice. I think one public body I have has access to what they call a telephone notification system. They sent a notice out. The next meeting will be virtual. Here are the access codes. So that's kind of a highly unusual way, but it reached out to all the people in the community to access the meeting. Other methods are we've done through the website. Some bodies do it through the website. Some bodies do it through public notice in the newspaper. Also posting on the front door of City Hall, for example, if it's a municipal client. So there are different ways to provide extra efforts. If you don't already do it that way, just go and the extra mile. If you have an email list, if you're a public body that has an email list of the public members who typically are involved in your meetings or interested in your meetings, and then you can ask them to send that out to others. Facebook has been another method I've seen public bodies use. So there are many different ways you can make extra take extra steps to let people know of the virtual meeting that's going to take place. We do highly recommend adding a conference call option as a backup to increase the public access options for the two main reasons discussed. One, there's a Court of Appeals case, a special appeals case that says that's an acceptable option, and our opinions themselves have said that's acceptable. And then advance notice is critical to the extent possible. Using the same notice process is recommended. If you've always posted your meetings on your website, continue to do so. Just note the difference that now it's a virtual meeting if that's how it's going to be held. Frank, did you want to add to that?
No, I think you've covered that very well, and we can move right to the next slide, which is talking a little bit about public participation. That's not an Open Meetings Act issue other than for an objection to the closed meeting, which is a fairly narrow exception. But as a public body, public participation may be required for many other reasons. And those are some of the practicalities, at least from our point of view, that we'll touch on. You know, you may have a public hearing requirement. Many public bodies will provide open public comment as part of their process. There may be other requirements that also come in and apply. What we would recommend is, regardless of what standard is put in place, there are different ways to do that to allow some element of public comment, that they be consistent, at least allowing equal access, even if it's not the same type of access that was there when somebody could simply step up to the microphone and make whatever comment they wanted. The focus should be on trying to maximize opportunities. That can involve scheduling oral comment. For instance, to say, we've got a meeting coming up tonight. We need to hear from you by 2 or 3 in the afternoon, by email or any other option. And we will then schedule you for being able to either call in or Zoom in or Google in or what have you. And we will then schedule your oral comment. That can work. an email option can also work. We did get some question on how to deal with cross-examination and adversarial hearings. Needless to say, those are harder because simply allowing public comment is allowing somebody to speak. Okay, you're all finished. Thank you very much. Cross-examination is employing yet another party. Well, actually, you have a witness, then you have somebody asking and somebody else cross-examining and potentially going back and forth. The only way to handle that is getting back to what I was talking on a bit earlier about being very, very deliberate and going step by step. That requires clear chair direction. Your chair has got to be ready to say, we're doing the direct examination now, or let's say it's a public comment process where, let's say in a development proposal, there's a right of cross-examination of that. Well, then allowing those folks to come in and cross-examine. It is fair. That doesn't have to be instantaneous because the system may not allow that. Again, it may be fair to ask in advance. This is the person who's going to be speaking. If somebody wants the right of cross-examination, we need to know in advance so that we can arrange that. Then you would walk through that process and handle it in a very deliberate way, moving from one side to the other. The difficulty anticipating potential problems can be if you have two different sides and you have fairly heavy objections going back and forth. And that may be more in a quasi-judicial setting, such as a landlord-tenant proceeding, if you have a landlord-tenant commission or animal control board, or a licensing proceeding that happens to get very adversarial. And that may require some coordination with your IT units to make sure both are on site. And again, clear chair direction as we go through there. And if we could move to the next slide, please. Again, we've touched on some of this already, so I'll just summarize that, again, public comment doesn't always have to be in person. Again, if you've got a governor's order saying you can't do that, or at least can't safely do that, then we have to follow that. But again, it has to be consistent. You can have prior notice and scheduling. You may allow allowance of email comment. It is certainly possible to say, for instance, we're going to have this public hearing or public meeting where under our process, comment is allowed. While normally your body might make the decision that night, one wise move can say, you know what? Because of our sitting situation, we're going to delay until the next hearing or the next public meeting. Maybe it's 2 weeks, maybe it's a month down the road, and give people in the meantime the chance to offer email comment. That can be another way. Again, getting back to what we were saying, that's maximizing the opportunity. It doesn't always have to be in the same way. Again, this isn't an Open Meetings Act requirement, but it is a practical element that we wanted to touch on. And if we can move to the next slide.
Okay, so other electronic deliberations on public business. This is an issue that has come up in the past year with the Open Meetings Act, Open Meetings Compliance Board. I'll touch on two recent opinions, but transmitting information by email, text, etc., without discussion is generally unacceptable at any time, whether during COVID-19 shutdown or not. And I'll give you, for instance, sometimes a public body might be trying to schedule a meeting, and they'll schedule a meeting, they'll email a notice or a request to all members of the public body and say, we're trying to schedule, give us your availability on such and such date. So there'll be an email, whether it's reply all or just back to the sender, about people's availability, or that's a typical one, or attached to the minutes. I mentioned the minutes before. That is an acceptable way to communicate. Approval of minutes is by email, very limited exception. As long as you're just transmitting information. Another example would be coming up at our board meeting, we're going to discuss this particular document. Might be a lease, might be a contract, might be a policy. You're just transmitting that and you're not asking for any response. That's okay. You're sending information for consideration. Once you get into a discussion and deliberation on public matters in text or email, where a quorum of your public body is involved, that's where the public body seem to be getting in trouble. For example, so say I sent out an email and I said, attached is a contract we're going to be considering at the next public meeting. And one member sends back, I don't agree with this contract because blah, 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 and gives a bunch of reasons. That is going to start getting into the problem. Now, that one email by itself may not, but then if other people start responding with their reasons for or against, then you're getting into deliberative process. So that's what the public has a right to observe, is the reasons why or why not the public body is acting a certain way. Thus, emails used by a quorum to deliberate any matters of public business may run into a problem with the violation of the Open Meetings Act. The cases I want to present and remind people of, these are on the Attorney General's website, and one of them was from 2019, July. It's the Talbot County case. It generated a lot of topic of conversation amongst municipal governments when this particular case came out. But the complaint there was that in a 24 to 48 hour period, the county council was asked to take a position on some bills that were down in Annapolis at the state level. And in doing so, there were over 15 emails over that short period of time, the end of which resulted in a majority of the county agreeing to take a position. So the key in that case was there was no actual meeting of the public body. However, because the communications were, we considered the short time frame and the fact that they were one after another, not always with a quorum, but they were involving the public matter or public business of whether or not the county council as a public body would take a position. So it required a vote, and they were deliberating about it in the emails. Those were the things that we looked at that threw the matter into a violation. If they had just been submitting the bills and then they met and then took a vote at a public meeting, that would have probably not been an issue. What we would have recommended in that case was to convene an emergency meeting, get out notice as quickly as possible, hold a telephone conference at which the public could call in, and then they could deliberate the matter over a phone call that was publicly observable. That would have been the preferred method. Unfortunately, there wasn't really any circumstance similar to this one enough in our prior opinions that gave enough, I don't know if I say gave enough guidance, but that was on point enough that could have prevented the scenario. It was a very unique scenario, but going forward, I think we've given clear guidance in a scenario like that. But that was very unique, as the emails were admittedly deliberative and they were over a short period of time, and they required an action by the body, the public body. Frank, did you want to add to that?
No, actually, with the next slide, I'll touch on some of that so we can move right along.
Okay.
A lot of what April's talking about, what creates a problem? First of all, when you're hitting reply all and you've got the group circulating emails, if it's informational, you're simply saying, this is what's on the agenda. Or if we're conducting a virtual meeting, this is how to dial in, or this is what we're going to do. That's fine. But what April was talking about was the issue of deliberation. What people have a right to observe is the deliberation. So if there's continuous deliberation on a matter, what do you think? What do you think? I'm not sure. Why don't we do this? That becomes deliberation. When you cross that line, that needs to be handled in some manner in an open meeting. Particularly, I mean, if it's a matter of what to include on an agenda, that's fine. But if it's a matter of public business, that's what the Open Meetings Act touches on. So even if in the past there's been some emphasis on simultaneous communication,
Mm-hmm.
but the Talbot County decision to some extent, let's face it, recognizing reality that email communication can effectively be deliberation among a public body because you're reaching a decision. So if you have effectively constant messages, and I believe Talbot County went over a couple of days, so it doesn't have to be simultaneous, it still can include the elements that require that to be handled in an open meeting. Now, there are options, which is what the slide talks about. as April just touched on, doing a conference call after public notice. We're becoming very well aware of the virtual options. That's what we're talking about today. You happen to have individual emails with, let's say you've got 5 members of a public body, individual emails to each. Let's say staff need a decision. If there's no interactive deliberation among that body, that should be fine. Let's say a letter needs to go out. I just want to make sure. If there becomes discussion and deliberation, well, I don't like what the letter says, or what about this, or let's see what my colleagues think. That's when you jump to deliberation. That's when the individual email route may not work. Certainly can do the online public meeting. Delegating to staff is also a possibility. Just want to say here's the general outline. Again, the Act prohibits evasive devices, which is what we've touched on. And as we come to the conclusion, I know April may have a few other things to say, but why don't we move to the next slide?
Okay, so I wanted to just touch on the invasive devices. There was another opinion that we did recently in it's the Howard County Board of Education. It's from March of this year. So that was a scenario where the board, the public body, while it was sitting in session with a quorum, several of the members of the public body were actually receiving text messages, some of them from third parties, and some of them were amongst themselves. So that was a very difficult scenario for us to analyze. But in order to, we looked at the purposes of the act and whether or not public deliberations may have been withheld from public view. And so what the board concluded in that case was, because the 2 of the members were communicating via text message while sitting on the dais, discussing, or at least the subject matter was with respect to the precise matter that was under consideration at that moment in time, even though it was in a text message amongst a quorum, because it was between 2 people who were actually deliberating at that time. The public had no way to determine whether what was in those text messages, what was affecting the decision making of those particular public body members. So that was considered a violation of the Open Meetings Act because it was considered an invasive device attempt. Even though it was unintentional, it was during the very topic of what was under consideration. That's what the topics of the text messages were. Now, there was a situation in that case where there were text messages from third parties who were not on the dais. The Open Meetings Act does not apply to people who are not members of the public body. So we didn't feel we had any enforcement authority, but we highly frowned upon that practice if the intent was to convince the public body member to vote a certain way, that where it would affect the deliberation. Because ordinarily those comments might be part of the public comment period and be open to observance by members of the public, where in this case, the information was submitted by text out of the public's eye. So even though we didn't feel like in that particular case, it affected their decision, there could be a scenario where somebody's lobbying a public body for a decision through text, and then that could become a problem. So we frown upon the practice because it evades the purposes of the act. In that particular case, we didn't feel it was intentional, but there could be a scenario where if it's deemed intentional, you can kind of find yourself in trouble. So I do direct your attention to that in terms of using electronic devices especially during a meeting. So there are remedies. What are the remedies for violations? Well, basically, right now, when we find a violation, when the board finds a violation, the public body must summarize the opinion at its next meeting, sign it, and return it to the board. So it's a very mild enforcement mechanism, but it's what we have been given by the state legislature. And I don't see any plans in the near future to change that, although some people have claimed that we need different remedies. But right now, that is what we are allowed to do. Another methodology is the court can overturn a public body's action in some cases, assess a penalty, and award attorney's fees. But again, that would require a party to bring the matter before the court. We don't have any standing or ability to bring any matters before the court. The Open Meetings Compliance Board is merely an advisory body at this time. Next slide. So for more information, I've already mentioned the Attorney General's website is a great resource. It has a closing statement. It has the Open Meetings Act manual available. There's also new frequently asked questions for meetings held during the COVID-19 emergency. And you can also take additional classes at the Institute for Governmental Service and Research website, and the link is listed there. And I believe Frank has taught classes for them as well. Is that correct, Frank?
Sure. Yes. Yes. And actually, I believe you did. You have started to do that as well. So we certainly do appreciate that. I think as we've gone through, I've been looking at some of the questions that have been coming in. We have tried to answer some of them, so we went a little longer than we were planning, but that's partly because we were building some of those in. But I do have a few. One that came in, and April, I think we should both be on because you may have some particular insight. But there's one question that if you have a subcommittee of a particular board that they meet for a recommendation to that board, is that required to be handled? How do they handle that in a closed session? Is there any open meetings requirement that would apply because they may feel that they have a pre-deliberative privilege? Well, the question to that would come down to me, what's the creation of that subcommittee? If that was an informal subcommittee that the committee itself created, and if that subcommittee is not in itself a quorum, then more than likely the Open Meetings Act would not apply. However, if that subcommittee was created in some formal way, which might be by resolution, might be by, if it was, for instance, by the same resolution, which does happen, or the same ordinance creating a public body, that this committee has hereby been created, that's when the Open Meetings Act does apply. And in that case, the same rules would apply in terms of making a recommendation. And in terms of recommending, unless there's some exception for a personnel decision in talking about a particular individual, more than likely that's going to have to be handled in an open meeting session. And I don't know, April, if you had anything else to offer on that.
Well, I think the main question that the Open Meetings Compliance Board would look at is whether it is a public body. How is it formed?
Right.
You're absolutely right. If it is formed by a informal action of a not, and it does not consist of a quorum, it's going to fall outside of the act. So a lot of public bodies may approve something by a resolution or ordinance, and that kicks it into the Open Meetings Act. That's one issue that we've seen. So as long as it's not an intent to evade the act and it is a true subcommittee to kind of investigate something and come back with a recommendation to the board, and it's not formed in a manner that is considered a public meeting under the act, a public body under the act, and I think that would be kind of like the best way to explain that. It really is factually specific. So, but that would be the key factor. And then the second factor is, if it is a public body, is it something that would fall within an exception that you could use it, one of the closed meeting exceptions. So that I saw the one that says, we have one question, can a public body, how about private chat among members in a virtual meeting? Again,
Yes.
if it's about matters that you're going to be voting on, that would be deliberative. So I would avoid that scenario. If it is something, what does the acronym CAT mean? What does that mean? We're looking at a resolution, and what does that mean? If it's just informational, like I don't understand what that term means, that probably is not going to be a problem. But if it's, hey, did you hear so-and-so is opposed to this? I think I'm going to oppose it too. That would be an example of, no, that's a deliberation.
I mean, that's very similar to when we're giving the normal training on in-person meetings, really to avoid side conversations on the same thing. That's the same standard apply there. And if it's on a public issue, just having a secret side conversation, let's say with your colleague, without adding that in, that potentially could constitute an open meetings violation, again, because of the public right to observe the deliberation. In a virtual setting, sometimes you have to establish some protocols and rules up front. For instance, in the Zoom meetings, there can be the private chat backdoor, Well, you can turn that off and not have that operate. And in many cases, that's simply a better option because, again, let's avoid the problem by taking away that particular option. So it's a good question because it is something that does need to be carefully thought through. And you want to be prepared for it. Another question has been, which I think is a pretty good question, can a public body deliberate in a public session and then vote by email? And I'll kind of pitch that to April because that's sounding like a pretty good board question. I would have some, because I would say the public has a right to observe the deliberation as well as the decision. The deliberation is part of it, but then voting quietly by email, I think you're opening the door to an Open Meetings Act violation, but April can probably add a few more elements to that.
Well, I was looking at that one and I thought, well, if the email is on the screen simultaneously with the voting, then and the public's observing that, well, I can't imagine a scenario where that's actually happening. But if that were the case, technologically, like maybe a chat or where everybody's raising their hands and you can observe the actual vote, then maybe
your point is it's observed.
It's observed, right? But my guess is email is usually private to the person, so that would not be something that could be publicly observed. So I would say, just looking at it from a technological standpoint, my way I understand the email, and that it would not be simultaneously observable by the public, I would say that would probably fall within a violation as opposed to a compliance.
Okay. I think we have covered.
Oh, I have one more. I'm going to adjust the agenda. Must the agenda list each item to be discussed during a closed session? The general practice is just the general topic to be discussed, because one of the issues that comes up is how detailed does the closed meeting agenda have to be? We've had some that were not detailed enough, but I think it just, when you do the topics to be discussed, it should cover what's being discussed and not go beyond that. So it doesn't have to be, as far as I've seen, and Frank, correct me if I'm wrong here,
No.
I have not seen specific agendas for closed meeting. It's just been a one item topic.
Well, there can be sometimes two related items or two items. And just as an FYI, the discussion has come up, well, we may have this other issue. Well, you're not limited to closing a meeting for only one reason. You can include two, and that can be a way to avoid an open meetings violation if you do touch on another subject. It should be fair. It should be something that you expect might come up and might be raised. But again, you're putting in the notice to let the people know, let the public know that's what's going to be discussed. Now, there was another question on closing statements. How do you suggest that closing statements that need to be signed by the presiding officer, how should they be kept when the meeting is held virtually? I don't.
Nope, we lost you there.
Sorry,
we lost you there, Frank.
For a minute. Sorry. I think we're back on. Sorry about that.
That's okay. I missed your last comment there, Frank.
What I was saying was the dealing with the closing statements that have to be signed by the presiding officer. Is there any difference as to how to keep them when the meeting is held virtually? Might be a matter of getting them signed remotely, but I don't think there's a big difference as far as retaining them.
That's pretty much how I would answer that. I mean, you get it signed remotely or as soon as practicable, and then they just need to be available for any requests by the public.
Yep, I think so. And is a call-in option for the public required under the Open Meetings Act, or simply recommended to accompany a video conference? I can tell you we're recommending it. And April had touched, and she could certainly speak further to this, but the reason why we're recommending it as a backup is because, first of all, things do occasionally go wrong. I've kind of blinked out a couple of times. It just happens. a conference call is a good backup option. Also, a conference call is what the Open Meetings Compliance Board has approved. Therefore, that's a fairly strong backup if that's something that has been approved, whereas virtual meetings, we believe and we would recommend that if we're hitting all of the requirements, advance notice, access, minutes afterwards, that if you're in compliance, there should be no problem. But we don't have an Open Meetings Compliance Board decision saying virtual meetings are fine. We do have that for a conference call. So that's really the thinking there. Is it required? No. It's not an Open Meetings Act requirement in any way. The requirements of the Open Meetings Act, again, are those elements: notice, access, minutes afterwards, essentially. There's also a training requirement, but that's really not as much focused on COVID-19. So, April, I don't know if you had anything else more to offer on that.
I will add, there has been over the past several years some movement toward having the Open Meetings Act mandate certain electronically acceptable means of hosting a meeting, and amongst other things, and to more specifically deal with electronic communications and how the Open Meetings Act applies. And one of the things that the board has gone back and forth with, and we usually, I shouldn't say usually, we have deliberated this at our annual meetings, is whether or not the Open Meetings Act purposes would be enhanced by having more explicit statements like, okay, if you do by teleconference, this is acceptable. And the reason why we've at least to date leaned against it is because we felt there was enough guidance in our opinions and the purposes of the act to kind of give people an idea of what would be acceptable, and that it is so fact dependent on what works in that for that particular public body. So we try to leave it flexible, but also give guidance that if you have a conference call that is publicly accessible, then you're less likely to have a finding of violation so long as everybody can observe the deliberations. And so that's why we put it out there. So it's not required, but if you use that method, there's a almost not an actual presumption, but at least you've taken steps to make us see that, oh, okay, you've done this. We've recommended this. This is something that is acceptable. Whereas if it was a bright line in the act, then everybody would have to be required, and that's not currently the standard. Now, that's not to say it may not be in the future, but currently we try to look at each case on its facts and lead the bodies to work with the procedures that maximize public accessibility for their specific circumstance.
Okay, I think that I don't know if I think we have touched on the questions that were raised, so we certainly appreciate the interest and folks for listening today and dialing in. I don't know if April, you have any final comments. Thank you for your assistance and participation in here. I think we have, particularly with your experience in working with the board, I think we have certainly offered a lot of information there. So we thank you very much. There is some feedback for future webinars. What you might like most about the program? What you like the least? How would you improve it? And what topics to see covered in future events? And there's an email address there that you can use. So I want to highlight that for everybody and thank everybody again. April, I don't know if you want to.
Oh, I